law firm Skarbiec from Poland. I would like to welcome all of you on our webinar about benefits of transatlantic business expansion, about how to set up a company in the United States. As we expect, most of our viewers are from Poland, so you would like to put this specific perspective for people who are raised in continental law background and try to establish a business presence in United States. From Poland. I would like to welcome all of you on our webinar. Just a second, we have some technical issue. Basically, we have certain clash of legal mentalities here. So first of all, in a continental law system, we are used that companies are established by courts. In United States, basically it's just a filing registration of company, and judges, they are not involved in company creation process. Then in Europe, we are used that whatever happens in companies basically is public. We file financial statements and they can be viewed by anyone. We file information on beneficial owners of companies and this information can be viewed by anyone. We file information on members and shareholders of companies and again it can be viewed by anyone. This is not exactly how American law operates in this area. Other differences which we see here are related to internal structure of the company. In Europe, you are used to so-called two-tier system, which consists of management board of the company and supervisory board of the company. Common law system works more on one-tier system. So basically, you have one board of directors which consists of executive directors and non-executive directors. It's a lot of differences, and because of this, I requested help of our renewed colleagues from Cullen & Dykman Law Firm from New York to help us to understand the American system, to navigate in this system, to understand the differences. And to help establish business presence in the United States. With me are two partners of Cullen & Dykman Law Firm, Maureen Monahan and Michael Trison. Michael, hello.
Hello, good morning. Thank you for good afternoon.
Good afternoon. It's a pleasure to be here.
Did you want us to begin now, Robert?
Yes, I think, yes. Okay, sorry, good. We have some technical issues here. So basically for the speed of connection, I have problem with seeing the other members of the webinar. For I apologize, probably it also negatively affects my fluency in this, but there is nothing we can do on this in this moment. I'm sorry for this.
No, that's fine. Everything is good. I'd just like to thank you for this opportunity and thank my colleagues also for being on the program today. I assume that most people who are listening and watching know that there is something unique about the United States. Some people call the word exceptional, but there's something unique about us in terms of our own historical influences, the frontier, people working together in order to be able to survive in a very hostile environment until they build something. And we're I would say culturally, we are a very practical people. So we lack some of the formality that is normally expected in Europe. I know that in my practice over 30 some years, dealing with Europe and Americans, that they're often surprised at the lack of formality that, as Robert said, we don't file all the papers. We have bylaws, but we don't file them. There is an ethic in America of just roll up your sleeves, get the job done. And I appreciate that. It means we have a very high gross national product. It means we live a affluent life relative to many other countries. But that's all based on kind of an ethic of get it done and also a belief, whether it's true or not, that everyone can succeed and you take pleasure from others' success, which is kind of the opposite of some of the feeling there is in some countries where people are resentful of the success of others. What we are trying to do today is talk about some practicalities about establishing a business in the United States. And for basics, I wanted to make sure that we all appreciated that unlike in some nations, in the United States, there are at least three levels of governance. There is a federal system with its rules and regulations, and then there is the state by state system, 50 states, and then there may also be some municipal or county regulations that can impact business.
Well, Michael, let me stop you here because this is the first difference for European customers. Because basically, if we establish a company in Poland, we will have common commercial law for the whole country. Of course, the company it has its registered city, in some voivodeship, but basically, it does not affect tax rules and it does not affect commercial law for the company. We have unified commercial law, and more or less they are the same taxes. We have certain real estate local taxes, but they are not substantial for normal business. As I understand, American system works differently. We can say about, and it's even in the name of the webinar, about establishing company in United States. While truth is, you don't establish company in United States. You establish a company in a certain state, and each state comes with its own totally different commercial law, which seem to be a little similar, but we cannot say that it's basically the same law in all of the states. Even more complicated is with taxes, because we will have one federal tax. So this is this corporate income tax, which we will say is in the United States. But apart from this, will be states where is sales tax, no sales tax, is income tax. We hear about certain states where actually there is no income tax. Then we will have counties, and we understand that in certain counties, those the most rich one and the most popular ones, you will have a local tax, which can be also significant. If you could a little bit explain us those complicated issues so we can understand them better.
Well, you've summarized that very nicely, and you've laid the groundwork for some of the things Maureen will address. But indeed, there is more similarity than dissimilarity among the various states, but there are differences. And we see that many companies wishing to incorporate as corporations will do so under Delaware law, for example, because of real or perceived advantages that they see in that. We had a recent case where our two firms worked on, where we incorporated in Delaware. We also needed to get certain permissions in the state of New York, including regarding educational system and uses of names, assumed names. So we're going to talk about that a little bit more specifically with Maureen. I think that the basic message we want people to keep in mind is what you've said, and that there are differences. There's taxation by the federal government. There also is taxation by state governments, depending upon the state, and so on. What I'd like to do is start at the beginning. When someone is considering doing business in the United States and they're from Poland, what are some of those first steps they ought to be thinking about? Well, obviously, if you want to physically go to the United States, you've got to start thinking about federal law that governs immigration. And for that area, we work very closely with Peter Cipriano and his partner, Pablo Velez. And we have been depending upon their good advice and experience because they're corporate lawyers who know a lot about immigration and different types of visas. So could I turn it over for the next few minutes to Peter?
Yes, so thank you both. Hi, thank you. It's a real pleasure, and I'm very honored to have been asked for this panel, so thank you very much. So, Michael, you really kind of hit it on the head. So one thing with regards to immigration is, I know that we were saying earlier that there's different level of governance. You have federal, state, and city. But for immigration, state and city doesn't matter. It's all federal. And the number one thing, which is really important with immigration, is immigration law is based solely on intent. And this is where a lot of people get in trouble. Now, every time you go to the border in the United States and you approach an officer, that officer is going to engage what type of intent do you have? Now, for Polish nationals, they're very fortunate because they're one of the few countries in the world that can use the visa waiver program, or ESTA. So if you're thinking about starting a business in the United States and you first want to come to the United States and just see if it's something you really want to do, more often than not, you're going to enter the United States on the visa waiver program, or ESTA. So what can you do on the visa waiver program, ESTA? Well, it's very simple. There's two things, two broad categories. You can come for business purposes, or you can come for leisure purposes. Leisure is if you want to take a holiday or a vacation. The real gray area is, what does business mean? And this is where some people kind of get in trouble. And how I like to explain it is that there's a difference between coming for business and coming for work. It's okay to come in for business. It's not okay to come in for work. And that intent component is what the officer is going to be looking for when he interviews you at the border. So what's business? Well, let's say you're thinking about starting a company in New York, and you're coming to New York to view the city, look at real estate, meet with potential clients, speak with advisors, attorneys, accountants, make the preparations that you would need to actually start a company. That would be considered business. Or for example, if you work for a company in Poland and you come to the United States on a business trip, that's completely fine. That's business. Well, what's work then? Work is basically coming to work for a company in the United States. Now, this gets tricky, and let me use a very good example. Let's say you're a chef and you're coming to a hotel in the United States, and you're going to go to that hotel's restaurant, and you're going to teach the chefs there how to cook. You're going to pick a menu with them, or you're going to teach them about, food preparation. That would be business. But let's say then you're planning on going to that restaurant and cooking meals for customers and serving them. That would be work. Business is allowed, work is not. So if you're coming to the US just to start doing the initial research project about starting a business there, you can just come on ESTA and you'll be fine. Now, the next question people are wondering is, well, let's say we set up the company and we meet other requirements. Well, what type of visas are available? And for Polish nationals, almost always I recommend what's called the E2 visa. Now, the E2 visa is an investor visa, and it can be used by investors, executives, managers, and specialists. So whether or not this is going to be a direct investment or it's going to be a company setting up a subsidiary, both people can use the E. So what's a direct investment? A direct investment would be an individual coming to the United States to start a company, to directly invest their personal funds in that company. Or if it's a company that, say, has a parent organization in Poland and they want to set up a subsidiary in the United States, that also can use the E2. It's available in both options. Also, what's really important is it doesn't matter if you set up a C Corp or if you set up an LLC, they both can be used for the E2. So with the E2
Peter,
visa,
let me stop you here to understand better the situation, because we have a few different levels where we interact with visa requirements. First is establishing a company. With this, we can say, how you said, if you want to research the market, you can visit United States. But we also say, to establish company itself, it is not absolutely necessary to visit United States. To our surprise, you can do this remotely. I say to our surprise because in Poland, establishing a limited company requires visit in front of notary. In theory, you can give power attorney for this, but anyway, somebody has to physically be present in notarial office and sign proper documents. In United States, most of states work on remote basis. So if you want to research the market, you will go to United States for business. But if you want to just establish a company, you can do this without a visit. But then we know that establishing a certain substantial business presence in the United States, making some investments can be helpful to this E2 visa. And rest of this thing is not very clear for us, because I understand they are not like very clear distinctions. You need to invest $100,000, $200,000, $500,000. I couldn't locate any specific legal rules about this. So what is exactly this substantial investment we should make? Then I understand this is a thing which is very interesting, because basically this E2 visa is then something we can use in future also for prolonged stays in the United States.
Well, you just asked the number one question I get asked about the E2 is how much do I have to invest?
Yes, this is exactly what everybody says.
The reason why you couldn't find an amount is because the amount's not written anywhere. How it's a sliding scale, and there's no set rule saying you have to invest this amount of money. The investment has to be appropriate to the type of business you're creating. So let me give you an example. If you are opening up a sales office, I think an investment, we've gotten E2s with an investment of 50 to 100,000 is more than enough. But if you're opening up a factory and you're only investing $100,000, you will 100% be denied. So the investment has to be an appropriate amount to open and operate the business. So it's a sliding scale. So I can tell you the lowest we've ever gotten was maybe like a $40,000 investment. And we've had people who've opened a $30 million factory to somebody who opens up a catering company, right? It really all depends on the type of business you're going to open. And once we know that, then we can kind of give you a general idea of how much you have to invest. There's also something that's extremely important. That's a very, very important distinction. Paid-in capital and investment income for visa purposes are two completely different things. For the E2 visa, they look at both. They look at how much cash is being put in the company, but more importantly, they look at how much is being spent. And what is being spent is what is counted towards the investment, not as what is being put in the company.
So we can say what matters is a real contribution to American economy. And so basically, this is amount of money put in the company, but creating a shelf company, even with bank account in the United States, depositing the money on the bank account is not enough for visa purposes. They will be looking for real business in the United States, operational business, and how much money you put inside this business. This is the question for E2 visa, if I understand you right.
That's absolutely correct. So there's five main requirements, and just to kind of tell you real quickly what they are, just the headline. So the first one is the treaty requirement. So Poland and the United States have a treaty, which is why they're even eligible for an E2 visa. Like, for example, China is a country, a big one, that does not have a treaty of commerce with the United States. So they cannot get, Chinese nationals cannot get E2 visa. The second one is nationality, which basically means that more than 50% of the shareholders have to have Polish nationality. The third one is the investment component. That, again, is how much money is being invested and spent in the company. The fourth one, and this is the one you hit on, is called real and operating. The company actually has to be real and operating. So real quick, what does that mean? Have an office, have staff. You only need to have one, really. Be spending money, be making money. You do not have to be profitable. You just have to be real and operating. And the last one is, and this is, you hit on this as well, it's a requirement called marginality. And that's just a fancy way of saying you can't be starting the company just to get a visa. It's got to be a legitimate business. So like you said, you don't have to be in the US to start a company. It's filing a single piece of paper, right? But you file a company, you open up a bank account, you put money in there, and you apply for a visa, it'll get denied because you're not going to meet that real and operating requirement. It's a process, and you have to meet all 5 prongs in order to qualify for that. If you do it properly and you set things up, the approval rating is very, very high. But if you try to do it, the worst thing you can do is apply too early. If you try to cut out the steps and cut corners, you're not going to get a good result.
Peter, thank you. I think we should circle back to you and maybe interject right now. We made references to different types of corporations. You mentioned corporation. We have the LLC, the limited liability company. Another form is partnership, and another form, which of course we never like to see, is people who are operating under an assumed name, but it's basically personal liability. We want to talk about the differences and why one chooses one over the other. But the general rule is you want to protect yourself from individual liability. I'd like to turn, if we might, Robert, to Maureen to talk a little bit about the different types of entities and where they get set up, how they get set up, and some tax implications. And then we'll circle back to Peter and other comments. Maureen.
Yes.
Yeah, hi. Hello, good afternoon, everyone. It's a pleasure to be here. So the U.S. corporation is an entity that is in taxes, we often refer to it as a blocker entity. The income does not flow through. A corporation pays taxes, a U.S. corporation pays taxes on its worldwide income. Currently, we have a flat corporate rate of 21%. We call it a blocker corporation because it essentially any foreign investor investing in the U.S. through a U.S. corporation will not have to file U.S. tax returns. So it's a big advantage for foreign investors entering the U.S. market. They will often use a blocker corporation to shield their foreign parent or foreign headquarters from having to file U.S. tax returns. The LLC is a form of entity that offers a lot of flexibility to investors who don't want to follow all of the formalities that are presented for a U.S. corporation. A U.S. corporation, the earnings have to be distributed pro rata. If you own 10% of the company, you'll have to receive 10% of the profits. There are rules as to how the management is conducted. You have a board director. It can be one director, it can be more director officers. A limited liability company is a vehicle that was established to offer businesses a lot of leeway in deciding how to structure their operations. You can have somebody owning 20% of the company but receiving 70% of the profits. There's all kinds of things you can do with a limited liability company, especially when it comes to joint ventures, when you want to give different parties particular unique rights or withhold particular rights. In addition, a limited liability company has the option to elect to be treated as a corporation. So you could start out as a limited liability company and then file an election to be treated as a corporation. So for example, a startup company, when it's making losses, may wish to be a limited liability company so that the losses flow through to the owner and they can use those losses to offset other taxable income. And then when the company earns profits, they may wish to be a C corporation if the corporation is reinvesting its income in the business, because the corporation pays a 21% tax rate, which is fairly low. The personal income tax rates, on the other hand, are up to 37%. So if you reinvest the money in the business, you actually are going to be incurring lesser taxes than with the flow-through entity, just because of the time value of money. The corporation, though, does have the negative effect of having double taxation. The corporation is taxed at the corporate level at 21%, and when dividends are distributed, they are subject to a second level of tax at the shareholder level. For dividends distributed to foreign persons, the default rate is 30%. Under the U.S. income tax treaties, that is typically reduced. Almost all European nations have an income tax treaty with the United States. For a Polish company, so for a company that owns at least 10% of the vote of a U.S. subsidiary corporation, the dividend withholding tax rate would be reduced to 5%. And in all other cases, it would be 15%. And the Polish taxing authorities should be granting a tax credit for the amount that was withheld by the US taxing authorities. So for a foreign corporation that is investing in the United States, I would almost always recommend, or it is very typical to use a U.S. blocker corporation. You establish a U.S. subsidiary that pays all the U.S. taxes on both a federal and state level. There's very little incentive for a foreign corporation to do business directly in the United States or for a flow-through entity, because the U.S. taxing authorities want to even the level the playing field between a corporation doing business directly, not using a subsidiary, and one using a subsidiary and having to pay taxes in the U.S. and distribute a dividend. So we have what is called the branch profits tax, which essentially, if a foreign corporation does business directly in the US, they will have an additional branch profits tax where they are paying what's referred to as the dividend equivalent amount in taxes. And that amount is computed through formulas that are contained in the Treasury regulations. So generally, it's simpler for accounting purposes and I guess saving costs for accounting purposes to file a tax return for a U.S. subsidiary than to file tax returns for a foreign corporation that is paying the dividend equivalent tax and having to use that formula, calculate the taxes, and prepare the tax return for the foreign corporation. There are certain scenarios where it is beneficial to use a U.S. limited liability company. One is if a Polish or European company is engaging in a joint venture with a U.S. business. The U.S. partners will often want to have a flow-through entity because for them that may result in a lower taxation. They often prefer limited liability companies, especially because if it's a joint venture, they probably may want to structure the distribution of profits and management provisions in ways that aren't as limited as they are for a U.S. corporation. And in that event, it may make sense for a foreign corporation to form a U.S. subsidiary corporation that then invests in the U.S. limited liability company. So the U.S. partners would invest directly in the limited liability company, would have a U.S. partner, and the foreign investor would have a corporate partner. So the profits would flow through the LLC, not be subject to taxation at the LLC level. They would be included, the profits would be included on the tax return of the U.S. corporation, and then distributed to the or repatriated by the foreign company.
Maureen, can I interrupt you? I hope I'm not going to divert your train of thought, but are there situations where a foreign state like Poland or some other country also taxes the American corporation because its shareholder, its owner is in their country? And the way it works with individuals, of course, in the United States, we tax worldwide. Are there worldwide taxes on foreign corporations?
If the income does not flow through the corporation, generally, no. A foreign corporation, I've never heard of a U.S. corporation being subject to U.S. taxes. I mean, it's an interesting question because, limited liability could potentially be treated as a hybrid entity, meaning one country treats it as a partnership. So they would say, well, it's not a corporation for our tax purposes. We're going to treat it as the income flowing through to, Poland. I haven't seen a foreign company under their domestic laws treat a U.S. corporation as a flow-through entity. That's the only way they could tax the profits of a U.S. corporation, is if they treat it as a flow-through entity. And I'm not aware of that, but there is an interesting, very interesting tax law in Germany, for example. And Germany says that the German tax laws say that if you conduct business in a foreign country as a partnership and you are taxed in the foreign country on the earnings of the partnership, you will not be taxed again in Germany.
Oh.
So what happens is that large German companies, if you look at all the big German automotive companies, Mercedes and so forth, they're all formed as LLCs, because what they do is they form an LLC, they elect to treat it as a corporation for US tax purposes. And under the German tax law, there was a decision that was rendered with 6 factors you need to satisfy in order to be treated as a partnership. So they will satisfy those 6 factors, which is, I guess, limited lifespan. So they'll give it, I don't know, maybe 30 years or something. You can always extend it later. And there's a couple of other factors. So by treating it as a partnership for German tax purposes and a corporation for US tax purposes, they pay the flat 21% tax rate in the US, and that's it. There's no the Germans have a US a zero dividend withholding tax rate. So if you own the 10% vote in the US subsidiary, so you can distribute the dividend free of US taxation, and there's no additional income tax in Germany. So it's a huge benefit because you're paying net altogether 21% taxes on the US income.
Marine, I have one question regarding choice of state, because the one choice our clients face is choice of legal forms, or corporation, limited liability, company, permanent establishment, and so on. But other is a choice of state. And we know from general knowledge that most of corporations then tend to choose Delaware. We also know that there are very big differences between taxation in different states, and some of them seems to be pretty substantial. For example, in Wyoming, there is no state level tax. In other states, those taxes, I believe, they are up to 10% or even little more than 10%, like in California, in New York. So the question is, first of all, if we have this ability to choose any state, or IRS will tax us, force taxation in certain place where we are actually conducting the business. Secondly, if we can make the choice, what is the most advised choice? If we should go for Delaware, which is the most common one, or you have some other options you think we should consider?
Well, the first choice typically tends to be Delaware, unless there's a reason to form it somewhere else. Delaware has, for decades, it's marketed itself as the place to form your corporation. So it's purposefully drafted its laws to attract attract companies from other states by not taxing them in Delaware if they're not doing business in Delaware. So you can be incorporated in any state. Incorporated in Delaware and do business and never do business there, but do business in all other states, and you won't pay income taxes in Delaware. You'll have a filing fee that you have to pay each year, but it's probably around a couple $100, sorry. And you need a registered agent. Registered agent is the person that would be served in case somebody needs to serve a notice on the corporation. They would send it to the Delaware registered agent. So there's also a very favorable body of case law to protect shareholders, directors, and also just the fact that there is sort of a very broad body of case law, because there's much more litigation in Delaware than in any other state. There's much more predictability for companies on how a corporate dispute will be resolved. And it tends to be much quicker in Delaware. They also have a special process that speeds up the process for resolving disputes in Delaware. So it is, it's shareholder friendly, offers the most protection, and can be less costly if there are some kind of corporate disputes because of this expedited resolution system. There are certain other states that can also be attractive because they don't have an income tax. I guess Wyoming is the one. Nevada is considered the Delaware of the West. I think it's very, very similar to Delaware. They probably don't have as much case law as Delaware does. But But if there isn't a reason to go to Nevada, I would typically go to Delaware. Maybe you wouldn't use Delaware. Like if you're a company that's just going to do business in New York or just do business in one state, you might incorporate in that one state. But if you're for foreign investor, I would generally say Delaware is probably the most attractive option because they probably will end up doing business in multiple states.
Maureen, have you heard any discussion about why other states don't try to copy the Delaware protocols so that they can get some of the incorporation in their state? Whatever the advantages are in Delaware, why haven't other states mimicked it?
I think Delaware has been, I mean, it's been in place for decades that Delaware has intentionally created this, to be known as the hub for incorporation. I don't think it would be that easy for another state to catch up to Delaware, even if they have very similar statutes. Creating a favorable body of case law would take a long time. So I don't know if a state would have, I don't know if a state would be able to take away the business from Delaware.
You made mention of case law. Let's emphasize that because in the United States, like in England, we have the principle of stare decisis, and laws in our country, decisions in our country, interpretations in the United States are very much reliant upon other decisions, so that under similar facts, the court should come out with the same kind of result. That's, of course, much different than in the Napoleonic system, the Napoleonic Code, and most of what prevails in Europe, including Poland, is pretty much black letter law. So it says what it says, and you follow that fairly strictly. Of course, it is impacted, I'm sure, by other decisions. But I think our participants in the seminar should be reminded that in the United States, in making decisions, your lawyers and you will look, and your clients will look at what courts have decided about certain issues under similar circumstances.
Correct. I guess another thing that's important to point out for tax purposes, as was already mentioned before, is that we have this two-level tax system, the federal system and then the state system. So each state has its own laws. So for a foreign investor, the federal level taxation is typically much simpler than complying with all the state laws, which are a bit of a maze, really. For federal purposes, you pay the flat income tax rate of 21%, and then you have the dividend withholding. The states all have their own income tax laws, sales tax laws, potentially some excise tax laws, and there are also certain local taxes. For instance, New York City has its own tax. In Los Angeles, many counties have their own tax. And complying on the state level is incredibly important for a business entering the U.S. market, because if you're not fully aware of the compliance obligations and you operate for a number of years without realizing that you're in violation, it can really take a company under, because if you're caught years later, the amount of interest and penalties that add up will be a huge hit. So for both sales and income tax purposes, it's very, very important to monitor all contacts with each state, because often there are not bright line rules as to when you become taxable in a state, either for income tax purposes or for sales tax purposes. Prior to 2018, we had a bright line test for sales tax purposes. If you did not have a physical presence in a state, then the state could not impose its sales tax on the company. Sales tax is similar to the
VAT tax in Europe.
The VAT tax. Thank you very much. Since 2018, in 2018, or it was 2017, the U.S. Supreme Court said, business is now conducted online. It's completely different with the Amazons of the world. states are no longer generating as much revenue through stores. You know, Amazon comes and sends all the goods into the various states. The states aren't making any income from it because they're not selling it through a store, so they can't collect the sales tax in the store. Therefore, the states are now allowed to tax the Amazons, any online business, and it's usually a certain threshold. You know, each state will have its own law, and then it will generally say if you have sales into our state of $100,000 or more, or New York and California it might be $500,000, or a certain number of sales into the state, we can impose our sales tax on you. And that created a huge problem for companies doing states in all the 50 states. Like, how can you possibly comply with all these laws? And since then, there have been a lot of software companies that stepped in. I think Amazon actually developed its own software in order to be able to comply with these laws. And now there's a number of companies, and we will point a business to, for example, Avalara, and they will implement software that the accountants can hook into, and that will sort of automatize the preparation of sales tax returns, which is has incredibly facilitated compliance. And for income tax purposes also, it's not always quite clear when you have to pay income taxes in a state. For example, you know, now there's so many people that work remotely since COVID. Perhaps you have a worker that wants to work in Ohio at home. That may or may not create a obligation to file income tax returns in Ohio, and you have to look specifically at the laws of Ohio to see whether or not that will create an obligation to file income tax returns there. And this is another reason why you want to have a blocker corporation that takes on all the obligations of filing all the U.S. tax returns, because that blocker corporation will register in all the states where they need to register for sales tax purposes or employment tax purposes, file all the tax returns. You don't want to have the foreign owner or the foreign parent company having to file all those tax returns.
Well, I have one very simple question for you. Simple from your perspective, but very intriguing from Polish perspective. And this is question of registered agent. Obviously, that any foreign business person establishing business presence in the United States is also kind of afraid of losing control over its business. From different legal systems, we know ideas of so-called nominee directors, which is absolutely no US theory, and by the way, is even of questionable value in other countries. But we know from countries like, let's say, Luxembourg, Ireland, Netherlands, Cyprus, Malta, they demand local directors in the company as a condition for local certificate of tax residency. What is also very inconvenient, because such a director is a person from outside business structure of the client. Is a matter of trust. It is a matter of confidentiality and plenty of other issues. In United States, as I understand, we don't have such issues. So basically, United States does not impose necessity of local directors. But we know that every company needs to have so-called registered agent, which is a position which is totally unknown in Polish law, and I believe also in most of European countries. We don't have registered agents. So if you could, Maureen, tell us in a few words, who exactly is registered agent? This is a government position, this is a company position, what are his powers, what are his obligations, how he's related to the positions of board of directors?
So the registered agent is, I mean, it's essentially a contact person that serves as the formal address where an individual can serve a notice on the corporation. So it doesn't impact the business, it doesn't impact the government. It's essentially so that if somebody is injured, for example, from a product that was manufactured faultily, and a legal notice needs to be served on the corporation, then there has to be a formal address where a potential plaintiff can serve their, their complaint, or it can be any other type of notice. So it's essentially just a formal address where you can say, okay, this is how I can specifically contact the corporation, and they have to acknowledge that they received this notice. And typically in Delaware, oh, go ahead.
It's not necessarily even a person. It's an address. It can be there's a corporation that does this for companies. So it's not an actual person, but merely an agency, an address, as Marina said.
So basically, this is just a technical position. The registered agent is not somebody who has equity position in your company. He does not have any management. It's kind of tricky because he intermediates with all official correspondence. So this is important position, but purely of technical level.
It's not all correspondence at all. It's not. Correspondence to the corporation goes to the corporation. The reason for the establishment is when there is something where you say to the world, if you want to send us something that's very important legally, that you want to sue us, give us notice. This is the address you use. But that address, that company or person that is the registered agent, has absolutely zero corporate power, no corporate position. It's just an address.
Okay, guys, because we already passed 45 minutes. I want to ask our team if we have any questions from the viewers. If so, we encourage you to ask your questions in chat. If not, I have a few more questions for you. But first of all, I would like to make sure if any of our listeners or viewers, they have questions. If we see anything on chat in this moment, just give us a second, please. No, we don't have still questions. So if the questions appears, we will stop and we will ask them. But if not, I have a question for you. How much time does it take to form, let's say, a corporation in United States? And I will give you a little bit context of the question. For example, in Poland, we have new form of corporate entity, so-called family foundation, Fundacja Rodzinna, which become very popular. And nowadays, forming Fundacja Rodzinna, family foundation in Poland, it takes around 9 months. To establish, 9 months, like a pregnancy. To establish limited company, if you go to a notary, you do this not with electronic system, but with notary, it will take few weeks for you. So the question from our perspective is how much time do we need to establish a corporation or LLC in the United States?
Maureen, you want to take that one?
Oh,
Wow.
Sure.
No.
I mean, you can create it as quickly as one day. A limited liability company takes a one-page document. I mean, all you list is the company's name, and not really very much more. And you file it with the Secretary of State. You can do it on an expedited basis, so you can get a same-day filing receipt. And similarly with a corporation, there's a bit more information in the articles of incorporation for a corporate entity, but not too much more. You have to say the authorized shares that can be issued, and have the organizer named in the document, and maybe a couple of other things. But it can also be done literally in a day, and you can draft the other documents, which are made public later, like a couple of weeks later, if you like, which is the resolutions of the directors that appoint the officers, and that through which they formally take all the corporate actions, the initial corporate actions of the corporation.
Okay, and how much of these documents can be accessed by public? And a little bit the context of the question is what I said in the beginning, that basically in European system, I believe everywhere in European Union, whatever is, do we have the vision? Sorry?
So, yes.
Okay, sorry. Again, we have some technical problem. I'm terribly sorry for this, because just finishing my question, whatever in Europe is related to the company, we need to file with authorities, so list of shareholders, list of directors, list of officers. list of beneficial owners in case shareholders are not beneficial owners, but they are hidden behind some kind of trust arrangements. All the financial documents, all of this we need to file with authorities, and basically all of this is publicly accessible. So the question is, how it works with American corporations and LLCs? What exactly we need to file with authorities, and how much of these documents can be accessed by interested third parties?
So generally, all this information is private. The certificate of incorporation or the certificate of formation for a limited liability company is filed with a state Secretary of State. There's not a lot of information on there. Neither the officers or directors are listed in there. If a business decides to do business in another state, they usually need to file a certificate in that other state pursuant to which they are registered to do business in the state. That might be publicly accessible, but that also just lists the name and address of the company, not maybe also registered agent. So the registered agent's name has to be public because the public needs to be able to have an address to send legal notices to. But other than that, everything is private. The documents appointing the officers and directors or formally taking corporate actions are not filed with any government agency. So you do not know who the shareholders and the directors are. And interestingly, we did have a couple years ago, we passed an act in Congress called the Corporate Transparency Act, through which we were going to try to be a little more transparent like the European countries, and it was going to require companies to list beneficial owners with the Department of Treasury, a special bureau called the FinCEN, Financial Crimes Enforcement Network, and that was to prevent money laundering and similar financial crimes. And it was completely unfeasible. It went back and forth to the courts. It was considered unconstitutional, then constitutional, and went back and forth. And finally it decided they got rid of it for US persons. But importantly, it does still exist for a foreign company if it does business directly in the United States. If it files a certificate in any state to do business in the state, then it will have to register with the Treasury Department, the Financial Crimes Enforcement Network, and list as beneficial owners.
Okay, so summing this up, we can say, I have one question from the chat, but just if I understand well, to sum up, everything is private unless we, the corporation, we LLC, choose to disclose certain information. Nobody can access, let's say, financial statements of the company in the commercial register or check who is the member of LLC. Other thing is that if you are a foreigner doing business in the United States, we need to file with authorities information about beneficial owners, but which stays confidential, is filed only with federal offices. Is it correct? Do I get this right?
Yeah, generally, a foreign company isn't going to have to name its beneficial owners because it will have a blocker corporation when it invests in the US. And if it has a blocker corporation, the blocker does not, no US company needs to register and report its beneficial owners. It's only a foreign company that does business directly in the US.
Okay. The question from the chat: what taxes I will pay in the United States if I pay dividend from US company to European Union shareholder?
So, is there such thing as a European Union shareholder?
Well, I read exactly the question how is in the chat. We can assume we speak about any of European Union countries. I understand why you ask, because what you want to say, as always with taxes, is incomplicated, no clear answer, but probably we need to start with double taxation agreement between United States and particular country in European Union, because European level we don't have income tax. But looking from American perspective, we want to pay dividend to any European Union country. We assume all of them, they have double taxation agreement with United States. How look the taxation from American perspective?
Okay, so the U.S. has entered into an income tax treaty with almost every European country. So there is a U.S.-Poland income tax treaty, a U.S.-Germany, a U.S.-France, U.S.-Italy. And the standard is that the income tax treaty says that if for example, the Polish company owns 10% of the voting interests of the U.S. subsidiary, there will be a 5% U.S. withholding tax. And withholding tax means the U.S. company actually has to withhold that 5% from the profits it distributes to the Polish company, because the U.S. taxing authorities know if they impose the liability for the tax on the U.S. company, they're going to get their money. Whereas if it's distributed, they might never get the money because it's essentially gone to the foreign company and they can't get it back. So the U.S. companies are strictly liable for that dividend tax, and if it's not paid, they will be liable for it. So that 5% tax, the treaty provides that the Polish authorities have to grant a credit for that tax. So when the Polish parent company files its tax return, it should indicate the amount, that 5% that it paid to the US, and get a credit for that against its Polish taxes. If the Polish parent owns less than 10% of the vote of the US subsidiary, the withholding tax will be 15%. Again, that's withheld by the US company from the dividend that it distributes to Poland. And again, the Polish taxing authorities, pursuant to the treaty, should give a full credit for that 15% tax that was withheld by the US.
Okay, I hope this addresses the question. We have 4 minutes left, so I have question if we have any other questions on chat. Okay, so if we don't have any other questions, Maureen, I would like to thank you, Peter. Thank you very much. Michael, you would like to add anything for our listeners and viewers?
Well, I think Maureen and Peter have covered their topics quite thoroughly, given the limited amount of time. I like to reflect upon and discuss with colleagues in the legal profession and with my clients from Poland the basic cultural differences can play a role in understanding in America why we do the things that we do. The accent is in European culture on formality, and in the United States, as I spoke about in the beginning of this presentation, it's on informality. Some of that has changed because of drugs and terrorism traffic, and that's when you start to see some of that system of being informal breaking down, because we're concerned about those two issues. But for the most part, I find my clients from Poland are incredulous at how easy it is to do things in the United States compared to other places. We barely ever hear about power of attorney, for example, in the United States. It's not that it doesn't exist, but it's not as omnipresent. Even speaking for a client, I have found in Poland, I need to have a power of attorney to act on behalf of my client. In the United States, one merely says, I represent ABC company and I'm doing this and that, and people accept it. And I've been asked by Polish lawyers, well, how can they accept it? How do they know you're not lying? And my response to that is, in the United States, there are people who lie, but for the most part, in the legal profession, that's the exception. And if somebody deals with me and isn't telling the truth, isn't upfront, they're going to soon find themselves disbarred, or at least they won't be welcome to do deals with other lawyers. So we very much depend upon trusting one another, even though we know there are exceptions. I think
I think in this moment we need to stop because we are running out of the time, Michael.
Okay, very good.
We have one final question from the chat. will LLC company will be able to set up investment account and participate in IPOs conducted in the US capital market stock exchange? It's a wonderful question and probably requires a little bit more time to speak, but let's try to answer. And generally, it's a question about foreigners forming LLC and trying to open bank accounts or investment accounts in United States.
Yeah, you can open a bank account with an LLC, although it's become much more difficult than it used to be for a foreign-owned company in general to open a U.S. bank account. So you probably need a lot of assistance on the ground in the U.S. It's become just a lot more tightly regulated. But that doesn't have anything to do whether it's a limited liability or a foreign-owned corporation. It's generally one of the officers or shareholders has to appear in person at the bank. So each bank is a little different. So it's good to have a contact at the bank that can facilitate the process. In terms of an IPO, for that you would need a corporation. And generally investors like to see corporations just because the typical documents that investors use are geared towards corporations. Like limited liability companies can have a lot of complexities, and investors are more familiar, or at least large investors, with the facility of corporate documents. And for the IPO, you will need to have a corporation. And there's different ways of doing that. You can convert the LLC to a corporation, or there's something called an Up-C structure, where there's a corporation that it gets the funding prior to and then acquires the LLC, so that the investors enter on the corporate level and the LLC is below the corporate entity that goes public. So there's different ways of dealing with that.
Okay, thank you. I believe that's all for what we have time. So I would like to thank all our viewers, our listeners. Thank you, Maureen. Thank you, Michael. Thank you, Peter. I think that's all for now. After this seminar, we will send also some presentations by email. Thank you very much. Bye-bye.
Thank you very much. Thanks, everybody.
Thank you.